Where do you draw the line between a criticism and a defense? That's the question we're asking after a late-in-the-day notice from Ken Paxton's legal team this week made a motion to quash the articles of impeachment brought against him.
Which Paxton's lawyers are trying to say this evidence should not be admitted, this wasn't properly done, and this information should not be presented to the Senate.
A motion filed Tuesday asked the Senate Court of Impeachment to do just that, either clarify the allegations against him or set aside the articles of impeachment entirely. But in doing so, they call these articles unconstitutionally vague and hopelessly vague, and label the impeachment effort a deliberately clandestine process. And the issue is Dan Patrick, acting as a judge in this trial, filed a gag order expressly limiting public comment on the trial and barring officials from giving any opinion as to whether the articles of impeachment should be dismissed or sustained.
The purpose of a gag order is to prevent prejudicial publicity that might bias potential jurors. In this instance, today we know exactly who the jurors are.
Not to mention, in the hours after this new motion was filed, Paxton's team sent the motion in a press release to media, and Paxton shared it on Twitter.
Is that a violation of the gag order by posting it so publicly like that?
So if it were my case in a regular court, I would always tell my clients, don't say a single thing, don't tweet a single thing, don't put anything on Facebook. What the Attorney General did with these tweets is getting very close to the line.
Notably, neither the press release nor the tweets include additional opinions or comments. They only quote directly from the motion, which could mean they didn't technically give their opinion per se, but that will ultimately be up to Dan Patrick to decide.
Thank you for watching. Please hit the subscribe button and get the latest news by downloading the CBS Austin News app.